Generally, when we look at estate planning, we want to know specifically the family situation that's involved, whether it is a very basic family structure that's made up of spouses and children that they have together. On the other side, we could have blended families where maybe we have spouses that come together that have children from different families. So there's a lot of different structures from a family perspective that we look into when it comes to estate planning. And the reason for this is that not all estate plans is a one-size-fits-all for every single family. It really depends on what are the goals of the family? What are they trying to accomplish? Who are they trying to care for? And this is why working with an estate planning attorney is so important, because once you are able to share what your goals are and what you want to accomplish, the attorney can help you customize an estate plan that actually fits your needs to make sure that your family's cared for. When we look at estate planning for blended families, it's important to understand what are the needs of the family? What are the wants of the parents involved? I have seen some clients where they have situations where two spouses come together and they have separate children that they don't share together, and they want to make sure that the kids are cared for. And what their concern is that if one of the parents were to pass away, now the surviving parent or the surviving spouse now has stepchildren, right? And the concern is that those stepchildren are going to feel like they're not being cared for in the estate plan. And so in those specific type of situations, we might offer to do a few different trusts where we have separate property trusts depending on what the assets look like. We might have life insurance policies that we would say, you know what, if one spouse passes away, let's have a life insurance policy that goes specifically to those kids so that they're taken care of from the estate. And then that way that the surviving spouse can use the assets that they need for the rest of their life. And it's not really this fight that's continuing to go on because they're cared for in the beginning. A lot of times people don't think that once you get divorced, you need to do any other estate planning. And that is absolutely not true. That is the utmost importance of the time to do estate planning. And the reason for it is maybe you had a plan before and some of the documents are not going to be valid anymore, or maybe you never did a plan in the first place. But the thing to think about is now that you are divorced, especially if you have children, if something happened to you and you have minor children, then the other parent of your children are now going to be the main guardians of your children if something happened to you, which also means that they now get access to any money or inheritance that you are leaving for your kids. And most of the families that I talk to, when they've gone through divorce, do not want their ex-spouse to get control of the money. Right? And so this is where an estate plan can come into place, where you can create a trust that specifically says, if something happened to me, I would want to make sure that my sibling or my parent or somebody that I trust was in charge of my kids' money, so that if something did happen to me and my kids were with my ex-spouse, now my assets from my trust are given to my kids pursuant to what my terms are and controlled by my sibling or my parents. So it's not my ex-spouse that's now in charge of my kids' money. It's somebody within my family that I trust to be in charge of it for them. I recently had a case where the father passed away and there was one minor child. The mother came to us after the dad had passed away and they were not married. At this point, the father had a very large life insurance policy where the son was the beneficiary of this life insurance policy. However, the son was 6 years old, so he couldn't actually inherit this money that he was receiving from his father's life insurance policy. And so we had assisted the mother in going through a court guardianship, and this was required by the life insurance company to actually receive that money for her son. Even though she was the only living parent, she had to show proof through the court that she was the guardian nominated by the court. And then that money was released to the mom for the benefit of the son. One of the things that I see a lot of times is once people understand that logistically this is how minor children inherit money works, then they want to know, well, how do I prevent this from happening? In this situation, if dad had not wanted mom to actually be in charge of that money, he should have had a trust in place. And that trust would have allowed him to put that life insurance policy to his trust if he had passed away, and it could be distributed to his son at 25, 30, 35, or whatever ages he set, putting the person that he would want to be in control of the money, also avoiding the need to have to go through court and get a guardianship.